everyone, welcome back to the second part of this week. Now we're going to move on and look at the second part of the court structure and organization. So we're going to look at some rules and policies that are implemented through the court system. Okay, so I'll share my PowerPoint with you. Okay, so when we talk about courts, in the last class, we talked about their organization and their structure. So we went through all of the main requirement or all the different parts of an organization, and we talked about how each of those fit into the different parts of the court, okay? So we went through each of these members, clients, structure, purpose, function, duties, of goals. So those are the ones that we talked about. So the last thing that we have to talk about this week are what we call organizational guidelines, okay? So organizational guidelines are the policies and practices and procedures that exist within the organization. So specifically, we're going to look at the policies and procedures and sort of rules that exist for the court system. Now, when you talk about courts, you have to understand that there are very strict procedural rules that have to be followed in any sort of trial. And these rules are set down in what we call federal rules. If you're in the federal system, and then the state has procedural rules if you're in the state system. And these rules govern everything that attorneys have to do and judges have to do within the courtroom. So there are federal rules for federal court, there are state rules for state courts, and then there may be local. So the state courts rules are for the whole state. There may be certain ones for county that are specific to the county. Sorry, hold on a second. Then you could have individual courts have their own rules. So whenever you're going to practice at a specific court, you have to know the rules that govern that court, and there could be multi-layers of rules that have to be followed. So you have the federal rules of civil procedure. So these are civil cases, that these are the rules you have to follow. And then there's federal rules of criminal cases. So if you have a criminal case, these are the procedures you have to follow. And then you have the federal rules of evidence. They're the rules that guide all of the evidence that's allowed to be presented at trial. And then you have current rules and practices and procedures, and those are different per court. So you have to always understand all of the different rules that govern people in the different courts. So it could be times where you have to give the other side things. There has to be certain notifications you have to give the court prior to trial, certain rules that exist during the trial. So there's all these different rules and procedures that attorneys have to follow within the court system. Now, I'm obviously not going to ask you specifics because it would be way too hard for you to identify specifics, but understand that these are the rules that govern all the procedures that occur in the courtroom. Now, when we think about procedures, we say, what is the main procedure used in the judiciary to achieve justice? So one of the things we talked about in the last lecture was one of the main duties and responsibilities is to interpret the law and to seek justice. So they're always weighing and balancing things to seek justice. So where does all of this justice occur? What procedures used to achieve justice? And it's the trial. Okay, so the main procedural thing that exists in the court system is the trial. Now, hopefully you remember from intro when we went through all the different steps, there's lots of different steps in the process. There's pretrial, there's discovery, there's the arrest, there's interrogation, there's all kinds of different things that occur. But the main thing in the judiciary branch for justice is the trial. So we use the trial to achieve their goal of justice. Okay, so if the prosecutor decides to charge Mrs. Smith, so remember our last example was Mr. and Mrs. Smith were married for a long time. Mr. Smith had terminal cancer, was in excruciating pain, begged his wife, Mrs. Smith, to give him sleeping pills to make him never wake up and die because he was in so much pain, and she did. Okay, and then we talked about which justice. So if you're the prosecutor, justice may be prosecuting Mrs. Smith because she broke the law and she committed murder. We can't have people in society deciding when people die. Or you could be Mrs. Smith and the defense attorney, and to you, justice is that nothing happened. She did what was just. She was helping her husband not to be in excruciating pain. There was no evilness. There was no bad thoughts. She was actually trying to help. So justice for Mrs. Smith could very easily be that she should just be let go and go home. or very minimum type of punishment. Okay, so if the prosecutor decides to charge Mrs. Smith, so if the prosecutor determines that justice is having Ms. Smith be responsible for her actions, what things could the court do to make sure that there is justice? Okay, so we have this trial and we have the need to have justice. What are the protections that exist to assure that a trial actually produces justice? This is what we call constitutional procedures. These are the procedures that are designed to ensure justice. We often refer to this as due process, right? Due process is fair process. What are the constitutional procedures that have to exist to assure due process or fair process? Well, it would include things like a fair hearing, which is the actual trial itself. The right, give rights to the parties. So each party has different rights that they're entitled to. The defense is entitled to Miranda warnings and the right to counsel. And you're entitled to the right against self-incrimination. You can't be forced to testify against yourself. And the right to cross-examine witnesses, and the right to a jury, and the right to a speedy trial. These are all what we call procedural, constitution and procedural rules or policies. So remember, that's what we're talking about, organizational policies and rules. While the court system's duty is to ensure justice. And how do they do that? They do that by following the constitutional procedural rules that are set forth. So although the courts have all of these statutes, the federal rules on civil procedure, federal rules on criminal procedure that are created by Congress, they also are governed, the court system is also governed by the Constitution, which sets out its own policies and procedures that have to be followed. Okay? Now, what is the main purpose of the trial? To determine the truth. So we said justice is truth, right? So the main purpose of the trial is to get at that truth. How do we get at that truth? So we talked about the Lady Liberty, and she's balancing justice. The whole idea is it's blind, it's impartial, and she's balancing everything. And the hope is to ultimately seek the truth and have the trial determine what the truth is. So then we have to think about, how do trials determine the truth? What exists at trials that lead us to finding the truth? Well, we find the truth by weighing the evidence. Remember, we are what is called an adversarial system. So we have the prosecutors on one side and the defense on the other, and they both present evidence, and then the jury or the judge weighs that evidence, and then hopefully we reach the truth. Okay, so that's what we do in this country. We have a trial, all of the evidence is presented, and then the judge or the jury weighs that evidence to help determine what the truth actually is. Okay, now when we think about trials, where do they take place, right? So if I say, oh, he's going to have a trial, where do you drive to go and see that trial? Well, it's in a courtroom, right? So the actual procedure that occurs is in a courtroom. We have special buildings that are designed specifically for the judicial branch for trials. So I want you to think about a typical courtroom, either you've seen on TV or that if you've been to a courtroom before and toured. How would you describe it? What does it physically look like? Like, what are the walls and the carpet and the chairs? And what does it physically look like? What do the decorations inside look like? What does the architecture of the building look like? Okay. So when you talk about courtrooms and the courthouse, you have to think about the actual appearance of it. And that's what we call the decor. Okay. So the decor is what the courtroom actually looks like. We also have this thing in the court system that's called decorum. Decorum are the rules and the sort of way that people within the courtroom have to behave. So the decor is what it looks like. Decorum is the way that people have to behave when they're inside the courtroom. Okay. So when you think about decor, we describe a courtroom. If you think about the Supreme Court, we have these massive marble columns, like massive marble columns. We have etched in statutes in it. We have phrases. We have things that mean things, every single thing. We have it says equal justice for all. So all of those things actually mean something specific, okay? So I have a video that I posted. I'm not going to play it here because sometimes I think it keeps me from being able to share it. But if you go in class and you click on it, it will give you a tour of the Supreme Court. So you can actually see what the Supreme Court looks like. And it's really interesting. It's short, but it's so beautiful. I strongly, strongly recommend that you look at and watch what the court looks like, okay? When you look at it, one of the things they have is what's called the chamber. And this is where the Supreme Court justices sit and hear the case. So this is a quick picture. It shows you these massive curtains. That's where the judges walk from behind to take their seat. All the judges are sitting here. They actually sit in a very specific order. The chief is in the middle, and then the most seniors on the right, the next senior on the left. So the people on the ends are the newest Supreme Court justices. You have attorneys that sit over here. Spectators are here. The parties that are arguing are here. Now, see, no jury, right? There's no jury because there's no juries in the appellate court system that's already been tried at the lower court. And other parts of the decorum are the ceiling, the chamber. It's very ornate. And the idea of the decor, that's very thought out. All of this is supposed to be grand, and it's supposed to portray authority and sort of a high level of intellect. So all of the things in the courtroom have a meaning, and the decor of it is supposed to project that meaning to the world. Okay, here's some more things. So you have the bench. This is where all the judges sit. What was interesting here, this was when Judge Scalia died. So they draped his chair to represent that he was no longer there. As you can see, this is where the attorneys would sit, and then they stand here at the podium to make their arguments. So the question is, why do we care about this so much? And it's kind of like what I just said. We want to project an image and a thought of the power of the court. And we're doing that through the court decor. Okay, so the court itself doesn't have, we said, police department or anything to enforce its decisions. So it sort of has to survive on that rule of law that we talked about, and to sort of encourage that and to kind of maintain the mystique and the power of the courts. We build the decor of the courts to represent power and authority and things like that. Okay. Now, what are some of the courtroom decorum that attorneys have to follow? So remember, decor is what the courtroom looks like. Decorum are the rules and policies and procedures that the attorneys have to carry out when they go into the courtroom. So if you're an attorney walking into the courtroom, what are some general rules that you have to follow? Well, number one, you have to be dressed up. There's a certain dress code for attorneys. They need to carry on that authority and that respectability. And that's why you don't see attorneys going to court with jeans and t-shirts. They most likely, the judge would kick them right out of the courtroom, okay? So there's how you dress. It's how you speak. You address the judge, your honor, when you speak. You stand up when you speak. When the judge comes into the courtroom, you stand up. So there's a certain level of respect and rules that attorneys have to follow. You don't have your cell phones on. You don't have your cell phones going off. So those would be the decorum of the attorneys. What about visiting citizens? Well, they don't generally have those same rules on dress, but you still have to speak to the court in certain ways and using your honor. And if you disagree, I respectfully disagree. So everything is done with a level of politeness and respect. And it's all part of that rule of law and what the decor is supposed to represent. Now, what is the debate for this week? And this is actually going to be your discussion, is should we have this adversarial system or should we have an inquisitional system? So we have an adversarial system. We have two parties duking it out at trial, and the idea is the truth will go to the top. There are other systems in the world that don't follow this method. They follow more the inquisitorial method. So England is much more an inquisitorial system. And this is where the judge really asks the questions and takes control, and the lawyers are just kind of there. So what we want to do is think about what each system is. So I posted a bunch of materials online that talk about the adversarial system and then talk about the inquisitorial system. You should understand what each system is and understand some pros and cons of each. Okay, so here's just a little slide summarizing adversarial system. The prosecutor proves the defendant guilty before a neutral judge or jury. So the judge or jury do not themselves take an active role in presenting evidence. They are just there sort of as referees and decision makers. Witnesses are called before the judge and jury, and the witnesses present evidence. The judge could ask questions, but they usually do not. It's usually the attorneys that do everything and present the evidence. And the truth is likely to be found when the judge or jury decides beyond a reasonable doubt. So both sides are going at each other, presenting evidence. And then the jury looks at all of this evidence, or the judge looks at all this evidence and says, is there enough evidence to go beyond a reasonable doubt? An investigatory or inquisitory system is very different. The judge is in charge. The judge takes a very active role. The judge can direct the police to go out and do more investigation. The judge can ask questions of the witness. So an inquisitory system could have a trial last for a while. They could start hearing some evidence, and then the judge would say, no, I need you to find more about this. And then the police have to go out and bring that evidence back. And then the judge will look at that and say, no, I really think we need this. So the judge plays a very, very active role, okay, in deciding what evidence is going to come in and what needs to be done. So there's written document prepared, used as evidence collection. Documents are presented to court with different judge. The court calls witnesses. The court decides who they want to hear from. And then the judge would determine what the ultimate decision would be. So that's what you're going to do for your discussion. We're going to have a little debate. Which system do you think is better? So make sure you look through some of the materials that I posted, and you want to participate in that discussion and talk about which system you think is best. So that's all I have, short and sweet. But I want you to spend a little time on the debate. If we were in class, we would have a formal debate. Can't do that because we're online. So I want you to use this sort of as a debate in class. So that's the last I'm going to talk about, and then use the rest of what would be your lecture to kind of learn more on your own. So hopefully I answered all your questions. If you have any other questions, remember I'm always here. Be happy to answer any more questions. And hopefully I'll see you soon.